area of controversy in the Japanese law literature, especially in English, has been this argument made by Chalmers Johnson and others that Japan has been, at least in the 60s and 70s, an administrative state. The theory or the argument goes that Japanese economic or ministries, especially economic ministries, have had very strong, or very strong discretionary powers to direct the economic performance and resources of Japan. And some have even argued that this discretion exceeds the law. And Merrill Dean, for example, from England, has even said that this type of practice is a threat to the rule of law. From your expertise as an administrative lawyer, what role do the courts play in reviewing or checking the legality of administrative decisions?
Okay, actually, I'm well, I would say a typical black letter law jurist, and I don't really prefer to speak about those big stories, but I do have interest in the theories by, well, the namely Chalmers Johnson, Meredith, etc. And the idea of at least one aspect of the problem, the legal judicial control of the administrative policy is well, relationship between the politicians and the bureaucrats. And of course, as you know, Chalmers Johnson's premises that in Japan, Japan has always been a country which ruled by more bureaucrats rather than the politicians. But people can observe that since beginning from the middle of the 1990s, the situation has been gradually changing. That the relation between the politicians and the bureaucrats are always an issue in this country. And recently, well, probably from the beginning of the Democratic Party's rule in 2009, and there has been a strong demand in the field of politics to have more political leadership as opposed to bureaucratic leaderships, and this trend has continued or even widened in the well, when the LDP became to resumed power. So recently, there has been many incidents in which that politicians are trying to take control of the, so to say, the I would say the treasure of the bureaucrats, or the well, I would say the which has been at least untouchable, has been untouchable. Once the issue which has been untouchable, the politicians are now began to be touchable by the politicians, and that has often been the target of the public discussion.
So, in terms of that shift from politicians wanting to assert greater policy-making influence over the bureaucrats, first of all, what was the trigger for that? What led them in the 1990s to say that things had to change? And legally, what were the techniques they used to assert greater control over the bureaucracy in terms of policy-making?
Well, first of all, the changes is in the middle of the 1990s when well, it was in 1993 when the Administrative Procedure Law was enacted. From that, the procedural control of the administrative decisions was has become an emphasis in the Japanese administrative law. And background for this law is the control to the administrative guidance, which has also, as you know, been one of the main theme of the Chalmers Johnson's. And he argued that administrative guidance is one of the effective tools which the bureaucrats gained control to the Japanese economies, and it is not the politicians but the bureaucrats who enforce such control. But the situation has gradually changed because that there has been a great criticism from the both well, foreign countries such as United States or the inside the business communities against used the administrative guidance, and the key word for the criticism was accountability and transparency. And so that the control to the economy has become since then more, so to say, legalistic as opposed to the past.
For our listeners here, can you explain or define what is administrative guidance?
Okay.
And also, to overcome some of these characterizations, what is its current legal definition?
Knowledge. Administrative guidance is a Japanese term in order to describe informal administrative activities, but informal and the distinction in formal and informal differs in, for example, in United States and Germany and Japan and probably in Australia. But the definition itself is very difficult. But at least the main essence of the administrative guidance is that without the legal enforcement power, or for example, just by recommendations, administrators can pursue sort of policies to the, for example, the economic activities. And for example, the what was a classroom example for that is the when the Japan and United States had a problem of the trade friction about the automobile export from Japan to United States. It was the 80s. And Japanese government had set a kind of quota for a maximum number of automobile exports without any legal ground. And the Japanese government had negotiated with the leaders of the business groups, and the leaders of the business agreed to such setting a quota, and those business groups had, ascribed the maximum amount of export to each automobile companies. In that, without any legal basis, that the Japanese government were able to pursue the very effective economic control, which was necessitated by the diplomatic relations, but without any legal ground. That's one typical example. That interesting example is an administrative about the local government. In the 1970s and 80s, the local government suffered from the very rapid increase of population, and they suffered from the lack of money, which is necessary for the establishment of schools or other public facilities. So what they decide is although there is no legal ground, that we would like to ask developers of condominiums to pay a certain amount as a donation. And of course, this is a donation. So since this is a donation, this should be voluntary donation, but there was, so to say, de facto binding power that, the developers feared that when they refuse such donations, that something bad will happen to them. So the local government can effectively collect money, which is necessary for public schools. So that now that as a result of the several court decisions, the Supreme Court had made a clear deadlines about the limit of the administrative guidance. So they had to basically, the idea is so long administrative guidance. First of all, local government can perform administrative guidance, but secondly, this administrative guidance has a limit in the voluntariness.
So on the flip side, talking about Japan and its administrative powers and so forth, is of course the role of the courts. Some have argued, for example, in constitutional matters, that the courts can be quite passive, very reluctant to strike down laws as unconstitutional. Other scholars, for example, Professor Daniel Foote, have explored the creative role that courts have played. In the context of reviewing judicial decisions, what techniques do the courts use either to embrace or to, proactively review decisions, and what type of doctrines have they articulated where they are reluctant to review decisions? And in your overall view, does that show a modern judiciary that is prepared to assert its powers, or do you agree with this scholarly assessment that Japanese courts are passive in the administrative law context?
Well, that's a very difficult question. As you mentioned, Professor Daniel Foote and Professor Frank Upham has well treated posited a theory that the Japanese code has been rather being active in the private law field, but not so active in the constitutional administrative law field. And on some point, that has theory has a persuasiveness. Professor Upham shows the example of that discrimination in the retirement age between the male and female in the and the Supreme Court has decided the case to be this is against the so the public policy of the Supreme Civil laws. Therefore, such kind of contract would be void. And of course, that kind of decision has a very great impact on the Japanese society itself. For us, that the people um, people often people who embrace judicial activity often complain the Japanese Supreme Court has rendered a very few decisions which declares the law to be unconstitutional, and it is partly true. But there are at least 3 points I can make about this theory. Of course, this theory is very attractive, but first of all, there may be cases which is both related to private law and administrative law. And for example, the atomic power plant is typically the case that for the operation of atomic power plant, both civil litigation and administrative litigation are both possible. And well, up to recently, people have wondered that there may be a possibility for the Japanese court to active involvement in APP theory in the field of private law, but not so in the field of administrative law. But very recently, Japanese district court has issued an APP in the Fukui prefecture to be that the approval, namely the administrative decision, is illegal because it has not the judgment process of the decision was not very proper. So that such kind of there has been a trend in also in the field of law in which court has tried to exercise control to the administration by using the control of the judgment process rather than result. Third point about the judicial review of the legality of constitutionality of certain laws, and there has been several interesting decisions about the discrimination, the inheritance discrimination between marital children and extramarital children, and so on. And in this field, the Japanese government, Japanese court has at least, well, not so frequent, but more than the past, more active in the controlling the constitutionality of the laws as opposed to before.
Finally, 2020, of course, has been the year of COVID-19. The whole world has been affected by this pandemic. In Japan, of course, during the pandemic, officials have also, this has certainly been the case in Australia, have exercised greater control, issuing public health directives. We can see that in the United States, for example, there's been strong political resistance to some of those directions, especially with wearing masks. In Australia, largely, there's been a little bit of resistance, but largely there's been compliance and acceptance. In Japan, how have the roles of local or state authorities changed in response to this health crisis? And do you imagine any new developments in administrative law or administrative review that might arise from this 2020 pandemic?
Okay, Japan has coped with the COVID-19 with the law about the swine flu, which has been enacted in 2012. And first, actually, that the law cannot be automatically applied to COVID-19. So the Japanese government changed the law in order to apply the swine flu, the law to the COVID-19. And um, first, it gives the government the powers to, well, declare the situation of emergency in the area. But the interesting point of this emergency declaration is that even with this the declaration, the rule of law does not change at all. That any kind of measures which were taken by based on the law is just a legal measure, not so to say extra legal measures, but which can be imagined by the term the state of emergency. And secondly, the one of the feature of the Japanese government response is that it uses, well, administrative guidance. Again, for that, of course, it may contradict the theory which has just developed now. That we can observe that administrative guidance is still a very powerful tool to guide people's purpose. Well, of course, Japanese government recommends people to wear masks, and this well, wearing mask is a very well, without any punishment or without the legal enforcement, it has been very well observed in the Japanese social, so to say, social space. In many cases, Japanese, especially local government, has often used the tool of public disclosure of non-compliance in the field of, again, for the administrative guidance. And in the field of this COVID-19, and this tool is used also by the national government. For example, based on the national government law, but used by the local municipal, local prefecture governors. Namely, that once there has been I'm not sure whether the audience of the year know about the pachinko, but the pachinko parlor is one of the, so to say, pseudo gambling place for them. And of course, this on pachinko parlor, there are people have gathered more, so there is a danger of COVID-19 infection in these areas. So, one governor had recommended based on those swine flu law that the governor recommended the pachinko parlor to shut down for a while in May, but the pachinko parlor didn't follow. And the law allows, in such cases, to disclose the name of the non-compliant pachinko parlor in that. And such kind of usage of such informal tool was discussed in the well, public communities, the public opinion. Some people say this is against the rule of law, but that is the tool which is prescribed in the survival law itself. So that such kind of usage has been often prevalent, but because of because of the outbreak of the COVID-19, this has again attracted the people's attention.
Professor Kadomatsu, thank you very much for your time and for your
thank you very much for your questions.
Thoughts and the administrative process and recent pressures due to COVID-19. Of course, COVID-19 has meant that the Kyoto seminar cannot operate next year in 2021.
That's a pity.
But we hope to come back in 2022, and I look forward to co-teaching with you again then. So once again, thank you very much for your time.
I'm looking forward to that.
Thank you.
Okay, thank you very much.